Welcome to Facing Future TV. I am your host, Raya Salter. I'm joined today by Thomas Linzey, Senior Counsel for the Center of Democratic and Environmental Rights, who has worked on some of the very first rights of nature laws. We're also joined by Frank Bibeau, tribal attorney for the White Earth Band of Ojibwe, who also works with the 1855 Treaty Authority and Honor the Earth. Frank worked with the White Earth on the law recognizing the rights of Manoomin, or wild rice, the first law to recognize the rights of a plant species. This included an important action filed last year in the tribal court of the White Earth Band of Ojibwe to stop the state of Minnesota from allowing water to be used for construction of an oil pipeline known as Line 3. I'm delighted and honored to welcome both Frank and Tom. Welcome, Frank and Tom.
Thanks for having us, Ryan.
You're so welcome. First, perhaps Frank and then Tom, please tell me a little bit of how you came to this work.
Well, in some ways, it's right straight from the creator. Partly as being a tribal member with the Minnesota Chippewa tribe, Winona, Leduc, and I are both enrolled at White Earth Reservation, and we've known each other most of our lives. And that goes back to when Tom Linzey was helping with her run for office with Ralph Nader back in '96 and 2000. And so Tom and Winona have known each other for a long time, and Winona had asked me about doing rights of a river, and it seemed a little hard at the time. And when we were talking, she said, well, then how about rights of Manoomin? How about rights of wild rice? And I said, now that will work because that's part of our treaty rights. The right to harvest wild rice is specifically reserved in our 1837 treaty. And I think that really makes it work the best.
Oh, fantastic. Obviously, well, for those who don't know, legends in the fight for Indigenous rights, for climate justice. Thank you so much for sharing that. What about yourself, Tom?
Yeah, so I came a slightly different path, which is that right out of law school began practicing environmental law. So did conventional, traditional environmental law, working to enforce the Clean Air Act and the Clean Water Act, and basically the list of federal environmental laws that we have. And for about 10 years, I did that work and came to the conclusion that the federal environmental laws really weren't about protecting the environment. And that sounds funny, but they're actually just about shaving off certain aspects of bad projects to make them acceptable enough so that they move forward. But they're not much about protecting the environment or the communities in which those projects are planned for. And so in 2006, we kind of changed gears and began asking the question about whether nature should have rights. People have rights. We're used to talking about human rights, civil and political rights, but we're not used to talking about nature or ecosystems having legally enforceable rights of their own. Yet we all rely on clean water and clean air, and without these systems, we can't survive. And so it seemed a natural question to us, and that led to the drafting. I drafted in the passage of the first rights of nature law in a little community just northwest of Philadelphia in Pennsylvania, which recognized that waterways had certain legally enforceable rights to exist and flourish, regenerate, basically these broad kind of constitutionally based standards, and kind of grew from there to the country of Ecuador, where we were asked to come in to help with the drafting of the new Ecuadorian constitution. And I think just to follow up on Frank's comments, that the tribal nations in the US have really been at the leading edge over the last 5 or 6 years on rights of nature work. And of those places where it's been adopted, I think White Earth has been the leader of those places as well in terms of bringing that first enforcement action and passing the rights of wild rice law.
Well, Tom, why don't you share just a bit of what are the rights of nature, and why is this so important?
Sure. So a lot of people think rights of nature exist without us having to lay a platform down to allow them to exist. But the opposite is true within our legal system. Nature has no rights within our current legal system. Nature is recognized as property. So if you own a 10-acre piece of land, the bundle of rights that come with that piece of land, with the deed, allows you, in fact, legally authorizes you to destroy that piece of land or to kill off the ecosystems, unless, of course, there's a wetland or some other more protected aspect of that property. But generally, the rule of property law is that you can destroy whatever you own. And so we've had a system of environmental law in the United States, which has somehow tried to base itself on this concept that property rights can exist as we know them, but nature can be protected as well. And you can't hold both of those in the same hand. And so the relatively new aspect of this rights of nature concept is lawmaking, that communities, municipalities, cities like the city of Pittsburgh, 36 municipalities, cities, towns, counties, villages, tribal governments have passed laws which recognize nature as having rights, which essentially create rights by recognizing these rights on behalf of nature. And it's only after that point can you enforce those rights. So you have to create or recognize the rights, then you enforce those rights. So coming back to White Earth, White Earth Business Committee, the government, tribal government, and the 1855 Treaty Authority passed laws recognizing Manoomin or wild rights as having rights. And then they stepped into the tribal court system to actually enforce those rights. So I've been to a lot of conferences where people like to talk about how much they love nature. We love nature too, but you have to take that additional step of seeing ourselves as lawmakers, actually drafting laws and passing laws to establish that platform upon which you can then begin to enforce these laws.
Thank you. That's so fascinating. Let me ask you, Frank, really the same question. And what are the rights of nature to you, and why is that important? And why is that important to White Earth?
Well, Tom's talking about mainstream kind of law, English law, American law, whatever. My background as a Anishinaabe, Chippewa, nature, we're part of nature already. And the creation stories, I've been thinking about them more and more often. And I've talked to some of my friends who are part of the Big Drum Day religious practices here within our communities. And I was talking to them about these different aspects of what's going on with rights of Manoomin and rights of nature. And the creation stories talk about us as humans being the very last creatures arriving onto the planet, and that the creator has to petition all of the other creations of life on the planet for us to come and live there and be able to live off of their existence. They become our sustenance so that we can live. And so we have a covenant from the beginning. And we have a covenant to make sure that it's always there for us, for them, and for our future generations. And so that's a different place to start. So in a way, that law exists already. Other Anishinaabe don't have to read rights of Manoomin to understand what it is, but you have to have it codified and written down so that all the other people can understand, or at least begin to understand what it is. And that becomes another mechanism of displacement of traditional state law, because that's what we're really up against first is state law. And states don't have power over tribes, but if we don't have a law in place also to essentially compete and or displace whatever they're doing, then we're going to end up subject to what they've been doing. And in a sense, that's the same with the federal government. So this is a third prong of jurisdiction that really hasn't been used in an effective way like this before. And, like Tom was saying, you have to be willing to not just engage and step in and make a law, but you have to go that step farther and you have to actually try to use it. That's the really hard part. I mean, you got to have all the pieces in place. And I think we do, because of Tom's past work, but you actually have to take that step. That's the crazy one.
That's extremely helpful. Help us understand Manoomin and why this is important. Why rights for Manoomin is important, or wild rice is important.
Well, wild rice is part of our creation stories where we were guided to where the food that grows on the water through prophecies from some of our elders. And so we continued to migrate through the Great Lakes until we found that place. And this place it was in Michigan a lot more. It was in Wisconsin a lot more, but it's certainly still a lot more in Minnesota and Canada. And so that becomes part of our most central part of our culture and traditions and spirituality. And so in a sense, I've had a connection to wild rice all my life. You know, my grandfather always made sure that we had wild rice wherever we lived in the United States. He'd always, have it sent to us or whatever. And so, and now it's my turn. I mean, I provided for my family and things like that. So, when you look at the connection of what it is for us with wild rice, we have no choice but to protect it. And by protecting wild rice, which grows in the air, grows in the water, and it grows in the earth, you're really protecting the water because it's very susceptible. And the state of Minnesota actually put a water standard together for sulfate standards like 40 years ago. And of course, now they've tried to figure out how to relax it for all the activities they want to do with the mining and everything else, And so that's always another aspect of what's going on. But that's, for us, I don't have a way out of this. I'm compelled to do what I'm doing. I'm just lucky, to have Tom helping me and have Manoomin choose me to, represent them as a client.
That is, I appreciate, what you say when you say you have no way out, in that, this is life's work, this type of advocacy. It's not a career. It's something that we are called to do. And I appreciate that very much. Maybe I'd like to hear from both of you. Talk a bit about this Line 3 case and what's at stake.
Probably most of the planet's at stake. I suspect that Line 3 is a global killer. If there's 20 global killers, Line 3 is probably one of them. It's the extreme extraction of tar sands oil up in Canada, and they figure it costs probably around $80 a barrel just to extract it and get it out of the ground to a refinery to make it profitable. And it's only recently that it would be profitable. Otherwise, it violates almost all the laws of nature, even calling it oil, digging it out through a mining process, thinning it down with all of these other kinds of PCB kind of whatever petrochemicals they're using. The whole thing is one giant greenhouse puff of smoke every time you think about it. You just say the words.
It's an abomination.
Yeah.
It's an abomination.
Yeah. And then it uses a pipeline. And we already have pipelines. They happened before us, in a sense, before we understood how to stop them. So we already had a corridor of pipelines. Right where I live in Ball Club, there's now 6 pipelines, and they wanted to replace one. And, we went through the whole struggle with the Public Utilities Commission and things to try to have it so that it was an in-place in-trench replacement. That's what the ALJ also said for the EIS. But the politics, which means the money of big oil, was able to say, no, they don't have to do that. Enbridge can have this other alternative route through a new territory, new wild rice. And they've already had they probably had 6,000. They've already had 5 or 6 major oil spills along the routes that exist. The largest inland oil spill in North America happened right here in Grand Rapids in 1991. The only reason people don't know that, and they think that Kalamazoo, which is also Enbridge, had that oil spill, was the largest because it happened in the winter time in Minnesota when the ice was on the rivers. And so the oil couldn't get into the water, and they were able to keep squeegeeing it up and sucking it off and putting it in the tanker trucks and running it back up to Clearbrook and putting it back into pipelines that were intact and pumping the oil out. And so it was never understood as the largest inland oil spill in North America.
Interesting. And so just for the folks who are watching, you're referring to Enbridge, which is the company at issue here that is looking to use this water to complete this pipeline, and apparently has been doing this for a long time in this area.
They have. And, we were just talking about this with the Corps of Engineers and the Minnesota Pollution Control Agency also, because, not only have they been doing this for a long time, but we don't see how they're going to end this game right now with the way they're showing they want to depreciate their pipelines. They want to accelerate it from a 40-year depreciation schedule to a 10-year depreciation schedule because they don't think that there's going to be enough demand for oil even in 10 years. And so that's really scary. Why invest all this money? Why go across all this new green spot and waterways and everything at the top of North America? So you've got the greenhouse gases, you've got the waste of all the materials that are being used for extraction, you've got the risk of all the oil going across thousands of miles of pipelines. You can go right down the list of what's wrong with this picture. And so, we tried to at least not let them have a second corridor. And that's what really concerns us, is they've achieved a second corridor. And we've also watched where the state of Minnesota has criminalized your public rights, your civil rights, your rights to assemble,
Yes.
things like that. Winona and other people have been charged with trespass in a place where we as tribal members have a right to be on public land. And just because the state makes a law that says you can't be on public land, we already have that right. So it's going to be a very interesting outcome to see how that plays out. It's very scary how militarizing it was. And that's what Enbridge did in the beginning with Sandpiper. When they found out they had to have an EIS, they jumped over to DAPL. And a month later, they were bulldozing down all the traditional and cultural properties at Standing Rock. So we expected this. We've been preparing for this. That's why we've got rights of nature. That's why we're doing a lot of other things.
And for the folks watching, he's referring to an EIS, an environmental impact statement, which is often one of the sort of first lines that these projects have to, one of the first requirements that they have to jump when they want to have these regulatory approvals move forward. And he talks about DAPL, he's talking about the Dakota access pipeline. It's important for folks to understand that these have been some of the most important and intense struggles in the, for climate justice that, in our lifetimes. So thank you for helping to clarify that and put that in context. And so I want to go back to Tom. Frank's talked about, and he'll talk more about the rights of nature, but he said in preparation, in the strategy of looking at these, at these forces bearing down, the idea of, uplifting the rights of nature as a legal strategy, came into the picture as part of the preparation. How do the rights of nature present this type of intervention in these cases?
Yeah, so Frank's comments make me think of the analogy, when you find yourself in a hole, the first rule is you stop digging. But we have a culture or society that seems to not be able to stop digging, at least a country that's unable to stop digging. And so I think the rights of nature concept makes the most sense when you see the overlap with things like tribal sovereignty, the authority of the tribe to make decisions about what's happening outside off reservation that may affect both things on reservation, but also items protected by treaties that have been entered into by the federal government and the tribes themselves. And so, but it's not just Indian territory or indigenous lands that are affected here. There are a variety of abominations across the United States. There's fracking, frac wells, these thousands of frac wells across the US. There's factory livestock hog farms that get put into unwilling, communities that are unwilling to have them or don't want them. Locally unwanted land uses is what they're sometimes called, or LULUs. But the fact is that we have to align decision making with those communities. We have to place decision making authority or reclaim it or seize it within those places that are feeling the impacts of these particular projects. Because right now, those projects are approved by entities that are sometimes 3,000, 5,000 miles away from the communities which are actually experiencing the impacts. And in the US, unfortunately, we have a Western kind of colonial system of law, which doesn't recognize communities, whether those are cities, towns, villages, or in some places and some occasions doesn't recognize indigenous communities as having those rights, but the right to make decisions to protect what's important to them, to those communities, places that are being impacted. And so there's this real cross overlap between rights of nature and community decision-making about communities having a say over what's going to happen and what's going to be protected, what has rights and what doesn't. I mean, all that kind of stuff. But unfortunately, under this Western system of law that we have, deprives local communities of almost all decision-making authority over whether something comes through or not. And so what we talk about a lot is communities having power to veto pipelines coming through. If a community that, understands the impacts and can show them these adverse consequences, then they should have the ability to actually stop the project from coming through that community. That's not the system of law we have in the United States. It's almost never been the system of law in the United States, except in the 1800s. And so somehow we have to not only begin to understand that we live in it, because we have this myth that we live in a democracy when we really don't, because we don't have any say over these things when they come through, except to do a 3-minute comment in front of an administrative agency at some public hearing. But we have to understand that and see ourselves as lawmakers, law drafters, law challengers, all those kinds of things that we don't seem to feel that we have agency over at this point.
Well, to that point, Frank, tell us a bit about how the White Earth created this right in tribal law for the Manoomin, and then drag the state of Minnesota into tribal court for this case.
Sure. Well, White Earth Reservation, we're all part of the Minnesota Chippewa tribe. White Earth and Leech Lake we're both parts of the Minnesota Chippewa tribe, and we're also under the treaties, we're part of the Chippewas of the Mississippi. And so we've created the 1855 Treaty Authority with both of those reservations having chairs that they always have positions on that council. And so that's kind of our off-reservation arm for protecting tribal members who are out harvesting resources, and to try to also establish protections from the state trying to regulate our rights, which under federal law, they don't have that right. And so we worked with Tom and Mari and everybody to try to create rights of Manoomin at the beginning. And we had that in place. And then at the time that we were doing that, White Earth Reservation also adopted at the same time for on-reservation, because they're not exactly the same kind of rights. So on reservation, the state already knows that the tribes essentially have exclusive rights with regard to the environment, like water and things, and they can do things in the tribal court. Off reservation, it's not been clearly understood how a tribe can exercise some kind of enforcement of the rights that they're asserting. And so here, what we did was, instead of having a reservation create codes and try to enforce them themselves, we're doing it through another arm, the 1855 Treaty Authority. And then we also did it with the White Earth Band, and we're doing it through the White Earth Tribal Court. So we have a court system that already exists in place. We extended the jurisdiction to also operate off reservation with regard to Chippewa who were engaged in either activities of harvesting or protecting and maintaining those natural resources. And so that could be a lot of people. That can be a lot of different Indians. And so that's the jurisdictional framework for the 1855 ceded territory, which is most of where the pipeline is in Minnesota. And then off-reservation, another nuance of that off-reservation right is because the reservation tribal government has more exclusive right on reservation, all tribal members should have a right to step up. We all have a right to speak up for wild rice. It's just that I'm also the executive director with the 1855 Treaty Authority, and I'm an attorney. And so as long as we're stepping up like we have, then we would be the first line of defense. But all tribal members have that right. And because you have that right, we also include in there essentially the right to protect your property use of recreatory property, your right to harvest wild rice, your right to access wild rice, your right to access fish. So you have a right to protect Manoomin, and that's a protection against the criminalization of those civil rights I was talking about, like with trespass. And so you're not trespassing, you're in a place where you're allowed to be, you're protecting property you have a right to and a right to protect. And so we're really using treaty rights in an environmental protection way to protect water, because if the water's protected, we figure everything else is much better protected by protecting the water than to try to figure out those other aspects of what to protect, because water is necessary for all life.
Right. And so what is the process then for, bringing the Minnesota into tribal court?
Well, it's a learning process. That's what it is.
Hello. He's a man of humility.
Yeah, no. It is. And I'm obviously still learning. And so one of the things that I learned, and you learn all this Indian law in little tiny pieces, but I try to figure out, number one, if you make a law, where does it go? How does it get appealed, and how do you defend that law in tribal court? And really, if by having a tribal law it has to go through to the tribal court process. And then that entity, if you have an appellate court, then it has to go through the tribal court of appeals. And then if that entity doesn't like what happens, then it goes to federal court. Now, it really hasn't been done with a government before, but we set up that jurisdiction and the rights of Manoomin to go off reservation against the government. And so, right. So we've added something to the law that hadn't been really contemplated before. And one of the things that we knew from Indian law, but hadn't used before, is that the 11th Amendment, which bars citizens from suing states or bars them from suing citizens or another state, well, we weren't citizens when that was made. We're Indians. We're Indians not taxed. We're Indians with treaties. And so that law doesn't prevent us from suing the state, but we have sovereign immunity that pretty much defends us from the state countersuing us like they have in federal court. And so in that sense, we're using a tool that I would say is at the height of our jurisdiction. If we have a right to decide who hunts, if we have a right to decide what our resources are and where they are and things like that, then environmental protection is necessary for our resources for food into the future. You know, there's a lot of things I probably can't defend past that, but I think those are inherent rights and treaty rights from the very beginning. We have 44 treaties with the United States. And so we're using Indian law from probably the best treaties. The Mille Lacs decision is a Chippewa treaty as well, from the 1837 treaty about wild rice as well as everything else. So the Supreme Court of the United States has decided in that decision that treaties are to be understood the way the Indians would have understood them at the time. We would have never understood this kind of pollution, degradation, killing water, killing off species for no reason whatsoever. We would have never contemplated that. Anything that's ambiguous in there, it's construed in our favor. So even if you don't think we've got it right in the paper, we still tell you what it is. And if you didn't pay us for it, you don't have a receipt, you didn't actually get what you're claiming.
So the existence of the wild rice and longstanding treaties, only strengthens this this creation of this right of Manoomin,
right.
or in theory.
Right. And you're probably aware, but there's some other cases going on, but for sure one with the salmon versus the city of Seattle right now. And I think rights of fish are going to be what really takes over the nation because they live in the water. Everybody knows what a fish looks like. Not everybody knows what wild rice looks like. They don't even know wild rice when it's on the plate sometimes and they're about to eat it.
that is true indeed. Tom, maybe you could speak to a bit, you mentioned the rice, you also mentioned the salmon. What is at stake with these cases? What are the opportunities and what are the fears in terms of these cases moving forward?
Yeah, so the implications are huge. It's about expanding or reclaiming, establishing what was originally understood as the intent and meaning of these treaties. So the implications are huge, especially for Indigenous communities who are working from that treaty perspective. Frank's being a little modest, I think, to put this in a slightly different cant, which is that the state of Minnesota was so worried about this lawsuit that they sued the tribe in federal court to try to stop the tribal court from exercising jurisdiction over hearing the case. So just to put it pretty starkly, here's the state of Minnesota that was so worried about the precedent that might be set over tribal community having veto control or other authority over permits issued off reservation, but in ways that affect treaties, but also may affect reservation land activities, having an impact on reservation land. They were so afraid of that that they went to U.S. District Court and sued the tribe, the White Earth Band, to stop the tribal court from moving forward with the case. So it's almost like we're in this weird situation where even talking to allies about these kinds of cases, that's so radical, that's crazy. But the ones taking it seriously are the folks that are impacted. So whether that's the corporations who understand very well what the impact of rights of nature could be if exercised on a wide enough scale, but also state governments who understand the potential for rights of nature to especially be exercised in coordination with treaty rights to give tribal nations control over currently what some areas of law don't recognize them as having control over. So the implications are huge here. And I think the implications are also huge for non-Indigenous communities like cities and towns and counties who are passing laws to reach outside of their municipal boundaries to actually affect stuff happening in other places outside their municipal boundaries that have an impact on ecosystems within their boundaries. So like the city of Pittsburgh, who has experienced chemicals being injected into their waterways upstream from the city of Pittsburgh municipal boundaries, would have a cause of action to stop that fracking chemical release because it violates the rights of the waterways as they flow through the municipal boundaries. So this extra jurisdictional aspect of rights of nature has huge implications because everything's connected to everything. Watersheds are connected to other watersheds, rivers are connected to other rivers through those watersheds. It can have a huge impact. It's just a question of kind of conventional environmental activists shifting gears to switch off this regulatory kind of model to something different. That's a huge piece of this.
So we need to take this very seriously. And don't worry, Frank, I know a man of humility and power when I see one. I was not fooled. Where are things going? How, just briefly, where are things standing with this case right now as right now going forward?
Well, the whole world's watching, and it is as important as Tom's talking about. I've just I got things going on, but it's, I'm just tired probably too. And the excitement, the thrills shrunk just a little bit. But this case, the crazy thing about this case in Indian law, because you have to know Indian law to understand the dynamics as well, because that's the only reason this works. So, Eighth Circuit Court of Appeals, when the DNR was first turned down by the Federal Court of Minnesota that said dismissed their case, trying to prevent us from exercising our jurisdiction against them, they appealed to the Eighth Circuit Court of Appeals. They also appealed to our White Earth Tribal Court of Appeals. And however it happened, they decided that there wasn't jurisdiction, and they just dismissed the case themselves. They didn't even remand it back to the tribal court for dismissal. Now, that's crazy, but that's beside the point. Usually there's some other pieces to it. So then the DNR sent that case to the Eighth Circuit Court of Appeals and said, hey, look, even the appellate court says they don't have jurisdiction. Well, by that time, we filed a motion for reconsideration, and we had to explain to the panel the mistakes that they had made in the reconsideration, which, isn't that easily done, but, in a kind way. But essentially, they had decided and explained what a federal court would probably decide. But the federal court is going to decide whether the White Earth Tribal Court of Appeals has analyzed our laws correctly, we've used those laws correctly, and the action that we've conducted is within the boundary of those laws. They did none of that. And so that's what we explain in our motion for reconsideration. You have to look at our stuff and explain whether our stuff works right. And that's what's going to matter. Well, then we sent that to the Eighth Circuit Court of Appeals as well. So in Indian law, back around Nixon time, ironically, they started doing self-determination, self-governance. They weren't trying to terminate us anymore. And so agencies were still trying to tell us what to do along the way. And so the courts would tell them that you can't interfere with our self-determination and self-governance. And sometimes the way I explain it is we can be in a wet paper bag as an Indian tribe, and you can see we're in a wet paper bag and where the exit is, but you can't tell us. We have to find our own way out. So, well, that's right. And so the Eighth Circuit isn't going to tell the White Earth Tribal Court of Appeals, anything until they decide. But the White Earth Tribal Court of Appeals would probably like to see the Eighth Circuit decision so they can get it right this time. But they actually have to get theirs issued, and then we can show the Eighth Circuit that we still have jurisdiction if that's what the decision is. And then the Eighth Circuit will probably rule in our favor as we anticipate, because the state doesn't have the case that it thinks it has. And that's when you're going to see a lot more tribes and other entities doing exactly what's going on right now. And that's what Jack's doing with the salmon.
Well, this is fantastic. We don't have a lot of time, unfortunately. So perhaps how can Frank and Tom, how can folks learn more and help on this effort?
So we have a webpage, and our organization is the Center for Democratic and Environmental Rights, which is www.centerforenvironmentalrights.org. And so, and in addition to just the learning curve, we have a 2.5-hour primer on rights of nature. There's other resources up there. A lot of wider stuff is up there as well. But resources also, I mean, these fights take money. So what Frank's talking about is a multi-pronged litigation in federal court and tribal court, setting precedent for the first time in most of these cases. And so, supporting Honor the Earth, which is the organization that Frank works for and that is spearheading these kinds of efforts. But reaching into your pocket, giving money for resources, coming up to speed, learning. But also, rights of nature is not a spectator sport. It can be done anywhere. It can be done in your city, your county. If you're a river keeper, if you're somebody that cares about a protected ecosystem or wants to protect it further to a higher degree, can be done in your place through a ballot initiative or through whatever. So that's what we assist with as people coming in the door to then move towards making those rights of nature laws.
We love to see it. That's exciting. Frank, do you have something to add there and how we can support what you're doing?
Well, Tom's really got it down. I mean, I have to kind of keep thinking of these things and figuring out how to keep going forward, have some patience. The work that Tom's been doing for a long time is really the core of what it is. I think what I've got going is just the best rendition maybe right now of what's active. I'm going to fall off to the side here in another year or two when all this stuff is working for us, and it'll just be that first case that happened, and there'll be all this other cool stuff that's happening across the board. That's what's going to happen, because once the states realize they're going to have to negotiate about the environment with tribes, they're going to quit coming up with a bunch of these crazy project ideas to begin with. That's going to eliminate a whole bunch of crap right there, because they think they can just get away with anything.
That's right. Well, I want to thank you both for this discussion. It was brief, but to me, fascinating and empowering. And thank you very much. And thank you for joining us at Facing Future TV.